Good afternoon. Here at the Australian Society of Authors, we advocate for authors and illustrators because if we don't, who will? Can we use that as our motto? No? Right, yeah. I'm going to use it anyway. Today our topic of discussion is, what the fuck, Australia? You see, in late 2011, the Attorney General launched a public consultation paper proposing to broaden the Safe Harbour legislation, focusing on redefining the phrase carriage service provider. What the frack does this all mean? And what the fuck does it have to do with me, do you say? Well, let me drop a knowledge bomb on your noggin. In response to the Australian-US Free Trade Agreement signed in 2005, Australia implemented amendments to the 1968 Copyright Act to minimise the remedies that a copyright holder could pursue against carriage service providers if copyright material was illegally distributed on their network, provided, once they were notified of the infringement, the copyright material was removed. Carriage service providers are your Telstras, your Optuses, your Dodos and the like. The people who provide the network infrastructure to allow you web access. That's fair, right? The government shouldn't be held responsible for drugs trafficked on public highways. So why should CSPs be held responsible for illegal copyright material that's trafficked through their networks, which is otherwise there for the greater good? As we all know, the internet and its surrounding environment has changed drastically since 2005, such as the motive for the proposed change to the legislation to include content service providers. These are your Googles, your Facebooks, your Pinterests, your ex-hamsters, for example. The Attorney General thinks, or thought, in 2011, that content service providers and the companies should not, on a policy level, be held responsible for copyright infringement that is unknowingly facilitated by their companies and its websites. According to the current state of law in Australia, these content service providers can be held responsible for individuals misusing their services to facilitate copyright infringement. Since the 2011 public consultation, the issue's gained traction. This has further led to inquiries to government and reports suggesting that the Safe Harbour regime should be amended. The last of these came directly out of its 2016 Productivity Commission report, which suggested a broader definition be adopted. The report suggests that this would also return fairness to innovative firms and other institutions such as educational facilities. This is supported by government comments on the issue from the Financial Review, which state, the government's intention is to develop safe harbour legislation that encourages the growth of the Australian digital economy, supports a thriving and vibrant creative sector, while supporting interests of copyright holders. Amendments to the legislation almost got through Parliament in 2015, but were halted due to extensive lobbying by copyright holder groups. No further decisive action has been taken in relation to copyright reform, although Parliament intends to hold more public consultations on the issue of more flexible copyright exemptions. Okay, in light of this fairly unbiased fact drop, let's take a second to consider the consequences of such reform. What do you reckon? What I reckon is there's two possible mindsets you can approach this issue with. One, the underlying social policy mindset, and two, an economic mindset. Both play an integral role in the analysis of why a slightly amended legislation proposal aligns with both the interests of organisations such as the ASA and its members, as well as content service providers. Killing two birds with one stone. Firstly, on a strictly policy level, it would be unfair to hold internet intermediaries such as the firms I mentioned before responsible for copyright breaches that are committed by independent users of the content service provider's services without the provider's knowledge. Whew, that was a mouthful. But in criminal law terms, the content service providers are lacking the required mens rea for prosecution. And such is fair in this circumstance because they're not meaning to facilitate and they're not knowledgeably facilitating a breach of copyright. They just are by virtue of providing the service that they're providing. Although the website, for example, may facilitate the exchange of copyright material, it would and currently is detrimental to tech firms who face litigation from copyright holders for essentially innocent facilitation of a copyright breach. Without delving too deeply into the domestic law of other countries, comparable nations such as the US, the UK, and Korea, south of course, have similar copyright legislation to what is proposed in Australia and is said to be thriving. The legislation obviously differs from nation to nation, but the basic premise is that it gives exemptions to content service providers from litigation from copyright holders if they're not aware of the copyright breaches. In these nations, provisions in the legislation require content service providers to be notified of the breach first and given a chance to take down the content. This would advantage both content providers and content creators in Australia, as the effect of these regulations would mean a more collaborative working environment between the two parties, and it would result in less litigated legal actions or disputes between the two parties. People may be asking why we should be protecting large tech firms from litigation because they can afford it, right? Yes, Google and other billion-dollar tech companies wouldn't bat an eyelid at the threat of litigation from an individual content creator. But when the power shifts in the favor of the content creator, it stifles investment and development in the tech sector, and has to the point where Australia is getting left behind in the global tech industry due to these restrictive laws. With the implementation of legislation such that is proposed, the balance between the rights of the two parties can be achieved by 1. Allowing the content service provider to be informed and take down any copyright breaching material without having to defend a legal action, hence minimising the apprehension to enter the industry or conduct business in Australia. And 2, by allowing copyright holders to bring the attention of a copyright breach to the content service providers without the cost of litigation. As the policy argument bleeds into the financial impact of the legislation, it'd be a good chance to transition the discussion into why the government should be implementing the legislation to the effect of the Productivity Commission's report based on economic reasoning. Prep for another knowledge bomb. Quick economics lesson. This is a supply and demand curve of a given product. Today our product's going to be an ebook, which is copyrightable material, words on a page, ones and zeros. It doesn't cost anything to duplicate or distribute illegally. This red line represents supply. This black line represents demand. On the y-axis we have price, and on the x-axis we have quantity. Where these two lines meet equals equilibrium. At equilibrium, you'll find a given price point for that supply in the market. For example, the price of the ebook is $10 at a quantity of, say, 100. If this ebook gets distributed illegally, the supply of the product goes up. Hence, the price of the product at equilibrium goes down. It's now $7. And the quantity has gone up to 120, let's say. What does this all mean? What all that crap meant is that when you illegally distribute a copyrighted material, it increases the supply and hence decreases the price in the market for that product. This effectively decreases relative value and is the economic reason behind a lot of the resistance to the change in legislation by rights holders. What's highly misunderstood by the rights holders is that the proposed amendments to the law actually make it less troublesome for the right holders to have their material removed, hence restoring relative value to the creator's product without detrimenting their bank account in the process of litigation against tech giants. Further, costs of litigation to small tech firms and independent copyright holders on either side of the table put pressure on industry stakeholders to either hold reserve funds, go elsewhere, or forfeit entering the Australian market because they're scared of being hit with a lawsuit. This isn't a recipe for a vibrant creative future where Australia can hold its own in the global tech industry. As a nation, we're severely lacking when it comes to the tech industry, and we're falling way behind other nations in respect to innovation, development, and investment in these sectors based on outdated laws which hold no grounds in social, economic, or logic policy. This is where I'm looking at you, Julia Gillard. Huh? Malcolm Turnbull? Jesus. How many have there been? Can't keep up. I'm looking at you, Tony Abbott. Technology is only getting more and more expansive, and if we aren't enacting laws that promote a collaborative framework between content providers and content creators, the firms will go elsewhere, and it'll make it even harder for Australian copyright holders to pursue an action or achieve a favourable remedy, which in most cases can be achieved by the removal of the content. If this doesn't happen, Australia is going to continue to fall further and further behind in an industry that's pivotal for the future of our economy. Coal doesn't last forever, you know. The basis of what I'm saying is that the introduction of these amendments would see copyright holders more effectively protected, because although they lose the right to sue the content providers for breaches without notice, they gain the right to have their content removed if unlawfully used for a fraction of the cost of formal litigation. This increase in access to justice for copyright holders also furthers the interest for content providers, as it allows them to focus on innovation and core business rather than worrying about taking provisions to prevent legal action, which detriments the domestic tech and creative sector as a whole. Hopefully what you guys take from this is that the introduction of the amendments will benefit both content service providers and rights holders in the process. It will facilitate a vibrant tech industry and culture that rivals any of our international counterparts coming into the future, which is what we need. If some or all of this made no sense to you at all, let me know in the comments below. Let me know what your opinion is. Are you a content creator? Are you a content provider? Are you Google? Let me know. All the information that's been collected for this presentation can be found in the description below as well. And until next time, friends, stay informed.